Welcome to the session on Employees Provident Fund Act 1952. With the industrial growth in the past years, some big employers had introduced the schemes of employees provident fund for their employees as a welfare measure. But these schemes were private and purely voluntary. Hence, what happens? These small employees or mid-class employers, they were not able to introduce this kind of a scheme for various reasons. Hence, for instance, in the year 1946, the Labour Investigation Committee went into details of the operation of the various government schemes operated by big employers, which is private and on their own. They investigated and they recommended that there should be a comprehensive act to legalize the entire system, and hence this act came into force from November 1951, and now it is called Provident Fund Act 1952. The act is applicable to all the establishments employing more than 20. Now there is a proposal to reduce the coverage from 20 to 10 shortly. I think the government is likely to take a decision on this. It covers all establishments irrespective of whether it's a shop or a commercial establishment or even education institutions. Everybody is covered if they employ more than 20. That's the condition. Then the act is also applicable to home workers who are engaged through contractors. Of course, normally this happens in the case of BD rolling, agarbatti rolling and all that. So the act is applicable for those people also. Here employee means directly employed or indirectly employed through contractors, whether within the premises or as home workers. The home workers concept I told you already, prevalent in such areas, or even it can be in other areas where the components are given for to clean outside at home and bring back, all these things. So they also get covered. All casual, contractual, temporary, part-time, even consultants, retainers, whatever the decision may be, engaged in connection with the work of the establishment, they get covered. Here, the nomenclature is not the criteria, but actually the nature of work. Some people may call as consultant for the base of designation, but actually when we go and see, they perform the work in a regular basis, so they cannot be classified as consultant and they cannot be excluded for the coverage of the Provident Fund. Only apprentices are engaged in the Apprenticeship Act, and apprentices engaged in the standing orders are excluded. But here also there is a word of caution, in the sense that apprentices engaged under the standing orders, if they are engaged in the true meaning of trainee, then you can get the benefit of this exclusion. But supposing it's only nomenclature, but the trainees or apprentices, we call them, but they do the regular work in the shop floor, then this exemption may not hold good and will not hold good. So this act is not applicable to established registered cooperative societies act employing less than 50 and without date of power. It's not covered. And establishment belonging to central or state governments and whose employees are entitled for their own pension schemes, so their own provident fund schemes by central and state governments, this act is not applicable. It means that government employees in the various departments is not applicable. Peace-rated employees, they are covered by PF as per the Bombay High Court decision in Hosur Bangalore. Part-time employees are rated. Retired employees are not eligible to cover PF. So if they are engaged after retirement superannuation and if they are fully withdrawn, their accumulations cannot be enrolled again. So this is very, very important. Home workers is covered under BD Segar Act, also will be covered under the Act. The Madras High Court has that the weavers and artisans who work as homers will also be covered under the Act. Because now you can understand the arm of application of Act is quite expanding. When apprentices, when doing the work of employees are highly rightly covered under the Act. I gave the example of apprentice, calling them apprentices, but I do the work of regular work, they are eligible for Provident Fund. Casual employees are to be covered. There is no distinction made between regular employees and the casual employees or even engaged by the contractor under this Act. Then drivers and conductors and cleaners of school buses engaged through transporters will have to be covered, obviously. Probationers need to be covered because probation is nothing but an employee under the Act. Daily wages, they are also to be covered under the Act. Drivers of executives, when covered, in one case, it was held that the drivers need not be covered since they are given uniforms, footwears or monsoon equipment, etc. given to other employees, then what happens? They need to be covered. Because what happens, though the executives were driver, the company may not pay the salary, but at the same time, if the other benefits are given to them, then it becomes the responsibility of engaging, covering them under Provident Fund. But supposing it is not so, in the sense that the drivers engage their own private drivers exclusively without giving any benefit or etc. as a regular employees, then he is not be covered because he is not considered an employee under the Act. So this distinction needs to be made very clear. Daily wager, yeah, is to be covered. Then part-time consultant doctors need not be covered because in particular case what happened, the part-time doctors, they work here for some time, they go to some other clinic for some time, from a hospital for some time, so they need not be covered. Then apprentice, under the Apprenticeship Act ought not to be covered, I told you already, there is an exception is there. When international workers, in the absence of social security agreement with a particular country, where from the employees have gone or come to India will be covered irrespective of their salary. This I will elaborately tell you when I deal with the chapter of international workers. Now here, the basic wages. Basic wages means all emoluments which are earned by an employee but does not include the cash value of concessions or any day allowance or presents made by the employer. So here, if you closely examine the definition of wages, it is inclusive of all allowances but exclusive of day allowance and house rent allowance, overtime allowance, bonus, commission, etc. It is exclusive of that. And any presents made by the employer. This, please keep it in mind when we discuss further. It means that what is the Provident Fund's PF contribution based on which to be given have been debated over a period of time that I will deal with later. Now, contributions is 12% of the basic wages and day allowance, including cash value of any food concessions or retaining earnings of any applicable to each employee. Hence, in order to understand the contributory wages, here we need to, both the definition of wages has to be read along with clause 29 of the scheme. Hence, the basic wages which constitute inclusions as well as exclusions when contributions appear. The subject matter of basic wages is under scrutiny by various high courts and EPF tribunals as well as before the Supreme Court. Now he said that in case of Gujarat High Court, he had said that all allowances other than HRA will be the basic wages which will attract PF contributions. Then in the case of Madras, Madhya Pradesh High Court, they had that transport, washing and special incentives are to be accounted for PF contributions. The division bench also upheld the judgment. So this judgment says that you need to take all allowances into account for the computation of considering as basic wages for the purpose of payment of contribution. And even in case of Madras High Court also they had conveyance arrangements, education, medical, CCA, special and food and so on, will attract PF contributions. So they gave a very, very wide meaning of interpretation of basic wages. When good work reward or allowance are not being included in exclusion of basic wage, hence PF contribution are also to be paid on this. Then they are going very meticulously to interpret the entire thing. Now, the thing is that these questions have been put before the Supreme Court now, because all the employees have taken the bid to the Supreme Court, because various High Courts have held that all allowances are called as basic wages, and then PF contribution will have to be paid on that. Now this is an appeal before the Supreme Court, and we have yet to see what the judgment of the Supreme Court will come, or whether the central government is going to amend the definition of basic wages or the contributory wages. We have to yet and see. So still the debate is hanging on in between. Then if the arrears is payable to workmen, then such wages will attract definitive yes. Then incentive and production bonus is not wages. So they need not be taken for wages, for PF contributions. When production bonus is not linked to productivity, then it will be deemed as basic wages. See, production bonus, if it is linked to production, then it is production incentive, then it doesn't count. But supposing production is not linked to productivity, then in one of the cases, Punjab High Court and even the Supreme Court has said that it amounts to basic wages. So the payment made up in lieu of notice period could not be in any sense regarded as basic wages, because it is not the wage emoluments earned while on duty. Payment in lieu of notice period in case of dismissals or anything, whatever you do, it doesn't call for PF contributions, because it is not earned salary while on duty. Hence, it need not be deducted. Then during the period of suspension, the employee does not perform his duty. When a person is placed in suspension pending inquiry, he does not perform his duty, and as such, the suspension allowance do not attract PF contributions. Then 1 month wages are paid under section 33(2)(b), also not representing emoluments earned, hence PF deduction will not be eligible. Then encashment of leave, not to be included for PF contribution in the case of Manipal Academy versus EPF, the Supreme Court has held in 2008 and does the law of the land even today. Of course, I told you already, good work, not included, but it has to be covered. All the above cases, as I said already, are challenged before the Honorable Supreme Court of India by appeals. The hearings are yet to take place, judgments are awaited. So we need to see and watch what's going to happen. In the meantime, the excluded employee, there is a word called excluded employee under the Act. What does it mean by that? An employee having been a member of the fund, if he had withdrawn the full amount of accumulation, he is an excluded employee. An employee who at the time he is otherwise entitled to become PF member exceeds 15,000 rupees per month, inclusive basic, is also an excluded employee. That means to say, if an employee joins an establishment without being a member earlier and his contributory wages exceeds 15,000 rupees, the employer has option to not to cover him because he is an excluded employee, or to cover him up to a limit of 15,000. So, in any case, you have to take the form number 11, a mandated form, under which you have to either to exclude him or include him. It has to be taken care of. If an employee joins an establishment has not withdrawn PF accumulation in the past, previous accumulation, then the employer has to cover him, either with a cap of 15,000 or actual salary. If all other employees are also covered with equal actual salary, this employee also has to be covered up to equal salary. It means that if a person has not withdrawn the PF contribution in the past, he necessarily has to be continued as a member with this type of condition. Then in the case of a peculiar case came, in case of Marathwada Gramin Bank Sanghathan versus Marathwada Gramin Bank, the case went up to Supreme Court. Here, what the bank did was that they issued a notice under Section 9A of the Universal Service Act. There is a change in service conditions to reduce the contribution of the basic salary for the purpose of contribution to the statutory level. When the case came up, it was 6,500 this statutory limit. They were paying an actual basic salary. So they gave a notice under Section 9A of the Universal Service Act, and then they brought down the salary to the statutory limit of 6,500. Here, the Provident Fund authorities, they put a claim on this and it went up. The Supreme Court held that since they have given already a notice of change for under Section 9 to all the employees, hence the government, the bank is entitled to reduce the basic salary to the level of 6,000 at that time. So this is a guiding principle. So here, friends, now we can also do that to limit the contribution to 15,000 instead of actual, but it has to be preceded by a notice under Section 9A or a consent to be taken by employees either through a union or a group of employees who have to take it. Otherwise, it becomes a null and void. Then coverage of retired persons. Now, this has been debated. This comes to everybody's mind very frequently. It comes. Here, if a person has withdrawn the accumulations fully, thus no longer be a member of the firm, then he is still an excluded employee and should not be covered. That is the total bar. He cannot be. But if a person is retired from establishment which is not covered under the PF Act, for instance, he has worked in an establishment, he was not covered under the Act, then he will not become an excluded employee and hence need to be covered. So this distinction. In the previous employee, if he is not covered, then he cannot be treated as excluded employee here and need to be covered here. Because he is not a member of Provident Fund anymore in that company. In your company, when he gets retired, though he is a retired employee, he is entitled for it because he is admitting for the first time. If he is retired from a central government or a central state government, and whether if he is withdrawn or have this one, then such persons taken as establishment will become a excluded, hence need not be covered. Then Section 2A, establishment to exclude certain department branches. Here, when an establishment considers different departments or branches, whether it's in the same place or different places, all such departments treated as parts of the same establishment. If one establishment is covered under the employer, the branch officers, whatever it is, it all gets covered under the same code number and then the coverage takes place. When exempted employee and exempted establishments, under Section 17 Act, there is a provision to obtain exemption from the application of the Act. Such establishment must constitute a board of trustees, a trust deed, registration and frame rules in such a way that the scheme is not favourable less than the provisions of the main Act. Then the central government and central PF Commissioner can grant exemption to such establishment to have their own private provident fund under these guidances. Then Section 7A is the determination of monies due to employers. So this is a very important section in the administration of Provident Fund. If any amount payable, if any due is payable to the PF Commissioner, if an employer has defaulted, or if there is short payment, or if he has defaulted in terms of not covering people, and the amount is due, all these questions will be raised in this platform. Section 9. If the Provident Fund inspector visits the place and makes an observation and makes a demand or issues a notice that you will pay, then one can always take the shelter of Section 9A and put the application before him, and this 9A proceedings shall be conducted very elaborately. The authority shall give full opportunity for the employer to substantiate or give its reasons or produce any evidence in his favor, and he will give full opportunity. After hearing the entire case, the PF Provident Fund, such authority shall pass such orders as deemed fit based on the evidences and circumstances put. So this is being followed. This is very extremely important. In fact, all the cases, 99% of the cases routed to the high courts and Supreme Court are all go through this Section 7A inquiries only, it goes that. So hence this assumes a lot of importance. When the order made under Section 9A, it shall be final and shall not be questioned in any court of law. But the only thing is, if there is any miscarriage of justice or some points have not been considered, or authority has taken arbitrary decision, or the decision is not based on some justifiable reasons, then the employer can go and appeal against the order. Hence, the powers under Section A appears to be quite bad, and a matter of fact, there is no provision in form that where demand section may be questioned. Since it makes a demand final, the judicial court is barred. It is paramount importance that while wide powers have been vested in the authority and further provision is not made to challenge the order, exercise of power should be made very careful manner that results may not be arbitrary. So if there is arbitrary, then you can always resort to appeals to high courts or even to appellate authority. So this is extremely important. Now here of course there are certain cases of important cases I will just tell you. When the authorities make a claim on contributions of unidentified employees are not taken. Now, for instance, many times it happens saying that we engage contractors to get the work done. We engage in the premises. As per the definition, the employees are also covered, contract employees are deemed to be covered under the employees' provident fund. For some various reasons, the contract is not covered and employer also is not covered. Then the question comes, if the authorities make an assessment that so many people have been employed and they were not covered and you have to pay the contribution at the set of so and so, then that claim is not admissible because you cannot claim the contribution on the unidentified people because you don't know, nobody knows where those people are, who those people are, where they are, nobody knows. Hence the court clearly says on unidentified people the claim is not admissible. So this is the position of law in short. And here many times we also come across the authorities will ask saying that the provident fund basic wage or the contributory wages shall not be less than the prescribed minimum wages. This question also came up under this section 78 in so many forums. But the tribunals have very clearly said there is no compulsion that the basic wages should be equated to minimum wages under the Minimum Wages Act, thereby including the house rent allowance, conveyance allowance under the Coverage Act. Hence the impediment order set aside and appeal is allowed. In the case of AP Manpower Services, then here, in this case what happened, AP authority held that all allowances shall form part of minimum wages and should be taken into basic salary for the purpose of coverage. Here the thing is that there is no mention of minimum wages in the PF Act. In Provident Fund Act, there is no mention of minimum wages. Hence, where the question of equating to minimum wages. The contributions of both employees and employees are to be paid to Provident authorities as stipulated. Any delay in remittance of contributions call for levy of interest, penalty, and even damages also. Para 30 of the scheme stipulates that the contribution in respect of employers and the employees of immediate employees, namely the contractors, are also to be paid by him or through the immediate employer. Under no circumstances no wages shall be made towards the employee's share of contribution. The principal employer to recover from the immediate. It means that what it says, under this, it is the first time payment. The employer has to pay both the contribution employer and employees of immediate employers also. Immediate employers also, it means the namely contractors. Now, on this, there is some diversified view on this fact. The immediate employees or contractors are also entitled to register and obtain Provident code, and it has been done now. When they try to obtain the independent code number, necessarily they have to submit all the documents and necessary papers as the principal employer gives, establishing that they got their own organization or entity. In fact, all the documents, like for instance, the certificate of registration in Shop and Establishment Act, or his articles of association, or list of directors, in case of partnership deed, or in case of proprietary firm, details about him, the PAN card details, the service, sale tax registration, service tax registration, and the list of employees he has got, the wage lists maintained by the particular establishment. All the documents need to be produced to PF authorities before for allotment of code, contending that they are an independent establishment by themselves. So, under the Act, when they obtain the code, they are independent organization by themselves. It means that once they get the code, they are obliged to follow all the regulations as per the PF Provident Act and scheme. Hence, it is their responsibility to pay the contributions on time and responsible for any delay, damage, etc. It is their lookout. The principal employer is not responsible. So this is one of the serious comment. Of course, it is supported by some case laws also, which I will share with you. Hence, the scheme of, in fact, in the case of Steel Authority of India versus the National Union versus Friend Workers in 2001, the Supreme Court held that the scheme of Contract Labour Act stipulates that the principal employer will not be supervising the workers of the contract, otherwise the contract system will be a sham, ruse or camouflage. In case of Pradeep Kumar versus Presiding Officer, the High Court of Punjab and Haryana also held that the employer-employee relationship in respect of principal employer would not exist if contractor engaged in supply of manpower is having valid license on the Contract Labour Act, records of payment of wages, attendance, show payments made by the contractor, EPF code allotted to work through the firm of the contractor, then the situation is different, that the employer, namely the principal employer, he is not responsible for delay or default in payment of contribution. In the landmark case, in the case of Food Corporation of India versus the Food Corporation Commissioner, PF Commissioner, the Supreme Court observed that it is indeed a large amount of determination of which Commission has only to depend on its list submitted by the workers' union. It is no doubt true that the employer and the contractor are both liable to maintain registers in respect of workers employed. The corporation seems to have some problems in collecting lists of all the workers, since they are scattered across the country. The Commission did not. Some of the contractors. Here they mentioned that the contractors also must have been summoned. They also should have been produced their cases in here. In the case of Madurai District Cooperative Bank, Madras High Court had very recently saying that by no stretch of imagination can be treated to be employees of the principal employer. With respect to the contractors who are registered with the PF department, they are to be treated as independent contractors. Hence, the petitioners cannot be treated as principal employers for the purpose of those contractors. In the case of Group 4 securities also, same thing has been held, that the contract is between principal to principal and there is not that of employer and a contractor. Hence, it is an independent establishment by itself. Hence, the company is not responsible for pay any penalty or liable for any provident fund, arrears, damage, etc. They are totally independent. In the case of Breaks India also, Madras High Court has the same point of view and say PF authority is not entitled to recover PF contributions or damages from the principal in respect of workers engaged by the contractors who have independent code number. So this is the provision of law. Then here, in the case also here, just for information I will show you 2-3 cases saying that the principal is not responsible for the contractor, in respect contractor who are registered, who have got independent code numbers. But the principal must still be responsible in case of contractors who do not have independent code numbers. Then is the responsible principal, that you can't escape. So the distinction here is that in case of registered contractors who have got independent code numbers, the principal employer will not be held responsible. But in case of unregistered or people who have not taken the Provident Fund code by themselves, the contractor, then the principal employer shall be responsible under the Act. This is how the distinction is made. So we need to have this very carefully. Then Section 9A also says that an aggrieved employer not cited the order passed by the officer in terms of some apparent error on the face of it on account of mistake or any reason can make an application to review the order under Section 10B. And of course, he can approach, thereafter he can approach the appellate tribunal or High Court or Supreme Court as the case may be. Then Section 10 of the Act protects the provident accumulations against any attachment, assignment or order of any court in respect to any debt or liability incurred by a member. It means that the provident fund is totally guarded. No court can attach the same against any conditions. Section 7A11 also stipulated in case of insolvency being a company, the order of winding up made the priority of payment of contribution over debts. So this is the first priority in case of insolvency. This is important to be given. Now here, employer not to reduce the wages, etc. Here there is a bar. You can't reduce the wages in the sense that contributory wages you can't reduce with a view to save money to deprive the workers against retirement benefits or applicable things. There is a bar against this. So this we must be very careful in doing this. It's not possible. So you can't do it. But only thing is, as I quoted the earlier Supreme Court decision, if you give Section 9A notice in ID Act, you can limit it to statutory limit. That's all, not beyond that. So we have to bear it in mind that in exercising this power, you have to be extremely careful. There is a total bar. With exceptional thing is that you have to follow these procedures. Then so 14B gives power to recover damages. Where an employer makes any default of any provident fund contribution by a fund, namely it can be provident fund, it can be deposit insurance scheme or pension scheme, the authorities may, in this behalf, may recover such damages as may think appropriate. Here also a detailed hearing will take place. The employer shall be issued a shock of notice and an opportunity will be given to present himself and put up his case in his defense, and accordingly the order will be passed by the authorities. Of course, there are some small decisions on this. While granting the damage, awarding the damages, it will be too harsh to levy damages equal to the amount of arrears as provided in Section B. Because here the amount of damages is not very specified, it varies. So one has to be careful and cautious. The authorities should really exercise proper assessment of the situation and levy damages. The financial difficulties cannot be valid ground for committing defaults on PF dues. No, that cannot be an excuse. Though the police PF commissioner has got powers in Section B, he should take into consideration various factors before levying the damages. The PF commissioner must take note of several relevant circumstances before levying damage for any delay in cases. Then here, as I said already in the beginning, there is a power to exempt, in the sense that the central government has a power to exempt the establishment, the application of this Act under certain circumstances. Here the exemptions are given in the sense that if the scheme of the establishment is equal to or more favorable than the PF scheme, then the government and the PF commissioner may grant exemption, and the establishment has to constitute a board of trustees and constitute a trust deed in line with the model suggested by the PF commissioners, and the conditions of which shall not be less favorable than what is in the PF Act. Then, on such circumstances, one can take exemption and you can have your own trust to manage the entire thing. Now here, all employees other than excluded employees are entitled should be enrolled as members. Any new member also to be covered from day number 1, he has to be covered. If an employee was a member of other establishment and he was covered under PF, so he has to be compulsorily covered. If an employee has ceased to be with the prior employment, after withdrawing all the accumulations, leaving the service, he is entitled to be enrolled as a new member if he is not an excluded employee. An employee who is a member of the fund in his previous employment after he joins a new establishment and also entitled to be enrolled, even though it costs more than 15,000 rupees, the coverage is, however, became limited to 15,000 rupees only. Here, of course, the contributions, it says, is 12% of the basic salary plus the day allowance and retaining allowance. It is responsible the employer to remit the contribution to the fund irrespective of the fact whether the payment of salary has been made or not. This is very important. We cannot take a condition saying that salary is not paid, we will not remit the money. No. The provident contribution becomes payable just at the end of the wage period. So it has to be deposited, the respective contribution has to be deposited irrespective of the fact whether the salary has been disbursed or not. So this is very important. And in case of contractors also, same thing holds good. So we need to ensure that the contract is also abiding by this kind of principle. Many times we find that the contractors do not remit the salary, don't remit the contribution on time. The excuse given by them is that saying that we have not received the bills from the company, so we are not paying the wages, so we will not pay the contribution. So this is not an excuse. Whatever it is, whatever arrangement he makes, the contractor also is obliged to remit the contribution within 21 days of the close of the wage period. It is very important. Now let me present you the amendment pertaining to the international workers. This amendment has come into effect from 1st November 2008. This amendment was made into being for two reasons. For one reason is that the people who are deputed from India to work abroad on various types of employment visas, they have to cover the dual coverage. In the sense, in India, because he happens to be an Indian employee deputed from the parent company in India, the contributions will have to be paid and the regulation will be, he will be covered here. But when he is deputed to foreign country, and since he is employed as an employee in that deputed for work in that country, then he has to be covered under the social security scheme of particular country. It means that he has to pay the contribution there also. So it means that there is double coverage. And the contribution what is made for social security scheme, the benefit he may get or he may not get, but he has to pay the contributions. So there is a double contribution. He has to pay in India as well as in that host country, and that deputed country. So the intention was to avoid such kind of a double coverage. From this point of view, Government of India has entered into agreements, social security agreements, that's called SSAs, with some of the countries. So both countries have mutually accepted that if I give a certificate saying that in India he is covered, then that particular deputed employee will not be covered under the social security scheme of that country. So it means the double coverage is excluded officially. Similarly, an expat comes to India from the country. If he produces the certificate of his audit certificate of coverage in that country where security schemes are there, where Indian government has signed a contract with him, when he produces here, then he need not be covered under the Provident scheme in India. So this is how arrangement has been made and being implemented. Of course, India has signed, but not all the countries, but some of the countries. For instance, US, still the agreement is not yet signed. It means that people who are deputed from India to US, necessarily they have to pay both contributions. In India also they get covered, in America also they get covered because they have to pay the social security scheme. And similarly, a US expat deputed to come to India and he works here, necessarily he will be covered here. At the same time, he will also be covered under the SSA scheme there. So this is the situation as far as SSA is international workers is concerned. So an international worker is one who is deputed to a country where the India has signed an agreement with them. He is called as international workers and he is called as an excluded employee. That's how it says. So, in fact, if a foreign expat for which India has signed the agreement, SSA, and he comes to India and start working, he is treated as a excluded employee and he will not be covered here. So that's how the situation is about this. I will just take you through the important thing. So India, in the first place, the international workers refers to only those employees who are deployed in countries with whom India has signed SSA. Indian nationals working in countries with whom India has not signed SSA are outside the purview of the term of international workers. I explained to you already. So any foreigner who is not in possession of Indian passport working in India in an establishment where employee prominent scheme is there, it becomes applicable if he has not signed SSA with those people. A excluded employee in international who is contributing social security scheme in his country of origin, who has signed SSA with India, based on which he need not contribute to the Provident Fund. And for this purpose, I told you already that they have to get the certificate of coverage in India, or he has to the certificate of coverage from that host country for people who come and work in India. So international workers other than excluded employees are required to join the Provident Fund with from 1/11/2004. In fact, India has signed only with 9 countries: Belgium, Germany, Switzerland, Denmark, Luxembourg, France, South Korea, Netherlands, and Australia. Australia is really recent. They are signed. So, barring these countries, then if any expat comes here, then he has to be covered. And any Indian employee who is deputed there, the double coverage still is inevitable. We can't help it. So only in cases where the agreement has been signed, then only if they produce the certificate of coverage, then they are treated as excluded employees and they will not be covered in the respective countries. This is how it is there. Now we have had a small table on the slide. You can have a look at it. On the right side, there is a category, and the middle one is impact in respect to SSA country and impact in respect to non-SSA country. Here, persons deployed overseas by Indian company or establishment. In respect of countries of SSA has signed, the contribution to be made by Indian Provident Fund, the rate limited to governed by SSA, and certificate of coverage is required. Then here there is no impact. Then impact on respect to non-SSA countries. Non-SSA countries, no impact, will continue to contribute to the social security scheme when to the host country. It means there will be double coverage. Expats who are deployed in India, no impact because contributions are required to be paid to Indian Provident Fund and Pension Fund in respect of SSA countries deployed in India. Then SSA impact of SSA in respect of non-SSA country, contribution made to Indian Provident Fund on basic salary and DA and retaining allowance. So here, if an Indian employee is deputed to a country which has SSA with India, then he will be continued to be covered in Indian Provident Fund on the COC being issued, and this employee will not be covered under the social security scheme of that country. If an Indian employee is deputed to a country which has SSA with India, then he will be continued to be covered under Indian Provident Fund based on the certificate of coverage being issued, and this employee will not be covered under the social security scheme of that country. Thus the double coverage is avoided. If an Indian employee is deputed to a country which has not signed SSA with India, then he will be continued to be covered under Indian Provident Fund, and at the same time he will also be covered under the social security scheme of that country. So double coverage will happen. If a person from foreign country who does not possess Indian passport and is employed in an establishment covered under the Provident Fund India, if he from a country which has signed SSA with India, and if he produces the certificate of coverage, then from the authority of his country, then he will not be covered in Indian Provident Fund. Then double coverage is avoided. If a person from foreign country who does not possess Indian passport he is employed in any establishment covered under PF India, and if he comes from a country which has not signed SSA with India, then he will be covered under Indian Provident Fund. Here there is double coverage. So the coverage is mandatory. There is no upper cap. It means the contributions will have to be paid at 12% on the gross salary as far as this is concerned, both international workers and the employer. It does not matter where the salary is paid, whether in India or abroad in his parent company. The coverage for criteria depends on extent of employee-employee relationship. That depends on the type of visa of entry. Whoever comes to India, what is the type of visa? If the entry is for a short visit, for technical or business meeting, etc., then the coverage does not exist. But of course, the employment contract must be looked into and to take a decision on this. By a notification dated 5th October 2012, the Ministry of Labour and Employment has allowed the international workers from the countries which have executed SSA with India, when they leave the country, they can withdraw the entire Provident accumulations, and when their employment in India is ceases. It implies that they need not wait for their 58th year till they get the benefits. They can withdraw the entire money on their quitting the service. So an international worker who is not an existing member of the scheme will only become member of PF and not pension. This is very, very important now. So they will not be members of pension scheme, but only that. For an international workers who is an existing member of the pension scheme as on 1st September 2014, out of the employee's contribution, 8.33 of the salary still required to be paid for the old people. The membership starts from day one, and there is no waiting period for this. Obligation for the workers is that every employer shall furnish within 15 days of the commencement scheme a consolidated returns, and he also said required to send monthly returns every month to the commissioner on the status of employment or exit entry of international workers. This is about the international workers. Now let me take you through a small session on the Deposit Linked Insurance Scheme 1976. This scheme is brought into effect from 1st August 1976. The scheme is applicable to all members of the Provident Fund. There is a contribution by the employer. Employer has to contribute 0.5% of the wages of the employees. The scheme provides for payment of assurance benefit to the family of the deceased member while in service, linked to the balance amount available in the PF accumulations. From 1st September 2004, the benefit is calculated, and the benefit is taken as average monthly salary subject to maximum 15,000 rupees, previous 12 months multiplied by 20 months. The benefit of the scheme shall be further increased by 20%. The maximum pension was limited to 3.6 lakhs. The assured amount limited to 3.6 lakhs. But now recently the government has amended, and they are making the compensation up to a maximum of 6 lakhs. So this is a very much beneficial scheme under this. Now here there is also provision by the authorities in case the employer wants to purchase a policy by approved insurance companies, then a policy can be taken by employer in lieu of the ideal scheme maintained by the PF Commissioner. For this, it is mandatorily required that the employer need to take permission from the PF Commissioner, respective PF Commissioners, giving details of the insurance scheme and the benefits. Based on that, the employer will be issued an order of exemption. Based on that, the insurance policy will be taken in lieu of EDI life insurance scheme. So this is the taking insurance scheme is much beneficial because the employer even he's in a power to enhance the contribution, or he can always add some more beneficial schemes in the scheme itself, which is more beneficial for the members of the deceased family. Now, I will take you through a pension scheme, 1995. First of all, the pension scheme was introduced in 1971 March 1970 when it was introduced. The scheme was provided limited pensionary coverage to the spouse or the minor children in the event of member's death while in service only. So they got a very, very limited approach. Then they thought that this is inadequate. They found a new scheme where they felt that the employee should also get the benefit after retirement during his lifetime, because he should get some retirement pension like that. And also in case of untimely death on account of the family also should be taken care of this. Hence a new comprehensive scheme has been brought into effect from 1985, and this scheme is considered to be one of the best schemes covering various pension benefits, family support and adequate security in case of certain unforeseen circumstances like death, disablement of to the fund member of the fund, etc. Here the membership eligibility is very, very simple. It means that all members of these PF who become a member of Provident Fund, he automatically becomes member of this fund. Automatically he joins this fund. There is no separate or additional contribution payable by the employees. 8.3% of the pay being diverted from employee's share of contribution. Now, of course, it is subject to a maximum of 15,000 per month. It will be remitted. Then 1.16% of the 15,000, subject to maximum 15,000, shall also be contributed by the government as per government contribution. The existing liabilities and the seized family pension scheme 1971 also shall become the corpus of the entire scheme. So the accumulations up to 15,1195 shall remain available even to the members in toto along with interest. So that will be calculated and actually calculate the pensionable service in the new scheme. Similarly, the balance of employees' contribution 3.67 will continue to remain in the Provident account of the member. Now, what about the benefit package? The benefit package is that the pension payment for life on retirement and superannuation. The pension payment of pension for life on invalidation during employment also. That is also quite possible. Then the pension is payable for a period of 20 years. It means that if a person retires in the age of 58, he will get the pension up to 78th year. And after 20 years of pension, instead of pension, at the age of 78th year, there is also provision to get the return of capital. It means that whatever money you have invested, the pension is being paid out of the interest accumulated on the contributions made by the employee during his service. Now the return of capital will be returned to him, it will come back to him at the age of 78th year. Now benefits package for the members. Pension payment for the members upon death of a member. The spouse will get the pension for life until marriage or until marriage. Then the children also get pension up to the age of 25 years for 2 persons. And children who, if they are totally and permanently disabled, then they will get for lifetime. Then orphan pension is also available in case of death of both the parents. Orphan pension also will be a provision to pay to the orphan till he attains the majority. The nominee or dependent benefits will get the life for life in case the member is unmarried and having no eligible family members. In case a person dies not being married but parents are there, then the pension will go to the parents turn by turn. First will go to the father, then comes the mother for life. This is how it is taken care of. The contributions to the scheme, as I said already. Now earlier to September 14, it is limited to 6,500. That is, an amount of 541 was being diverted from employees' share. But after 1st September 2014, in view of the amendment of the Act to 15,000 rupees, the contribution to pension scheme will be 1,250 per month. The central government also contributes 1.16% on the salary subject to a maximum of 15,000 rupees. Pensionable service. Here, the pensionable service is the total number of years of service of contribution to the scheme. Any change in the employer by a member, and if has successfully transferred the accumulations of PF, the total number of years shall be taken into account. So, only thing is one should ensure that there is continuity in membership, that is, he should transfer the PF accumulation from one employee to another employer, then his pensionable service gets intact. Pensionable salary, this is an important thing. What is the pensionable salary? Here, the average monthly pay drawn by him in a span of 60 months preceding the date of his exit. However, this is subject to maximum of 15,000 now. But prior to September 14, the maximum limit is 6,500. So beyond September 14, the maximum limit is 15,000 rupees. Now the calculation of pension is also divided into two parts. Here, the maximum pensionable salary limited to 6,500 rupees for the service period up to September 14, and the maximum pensionable salary limited to 15,000 rupees for the service after September 14. So pension will be calculated in two steps. First step, they were earlier to September 14, the pension payable. Then the pension payable for beyond September 14, the other steps. Both will be added, and subject to a minimum of 1,000 rupees, the pension will be paid. The pensionable calculation of pension is very easy. It is just the pensionable salary, that's what we discussed just now, multiplied by the pensionable service divided by 70, that gives the pension available. Withdrawal benefit. Supposing if the member has not rendered eligible service required to prescribe under this paragraph, that is, he is eligible for, if he contributed 10 years, then only he is eligible for the benefit. But supposing he leaves and quits the company earlier to that, then he is entitled to withdraw the benefit as laid down in the table, or may opt for scheme certificate. He has got two options. One is that as per the table, he can ask for the withdrawal, whatever the accumulation he has got in pension fund, as per the table D, he can get it back. Or he can ask for a scheme certificate. If he gets a scheme certificate, he should preserve the scheme certificate and then produce it at the age of 58th year along with his papers. Then he will start getting the pension. This is also available. Pension on exit and retirement as calculated, minimum pension is 1,000 rupees. Widow pension as per table C, now the minimum is 1,000 rupees and maximum will be 2,051. Monthly children, it is 25% of the widow pension subject to a minimum 250 per child, limiting it to 2 children. Orphan pension is 75% of the widow pension subject to a minimum of 750 per month. The question of return of capital I explained to you, I told you. The pension is payable for 20 years starting from the age of 58 years. After 20 years, the withdrawal will be available to the person so paid. The calculation is like this. The pension payable to him multiplied by 100 times, that will be the return of capital. For instance, if a person is drawing a pension of 4,500 per month, the pension will be paid for 20 years. Return of capital will be 4,500 to 100, it comes to 4.5 lakhs. So this is the money what he is going to get. So in short, this is the scheme of Provident Fund and international workers and deposit insurance scheme and employees pension scheme. Thank you.